All right, folks. Hello and welcome to another Launcher live stream. Launcher, of course, is the Washington Post's video game and esports vertical. Today, we've got a wonderful slate of guests. We're going to be talking about the Epic versus Apple trial, all of the things that have been going on so far. I believe at this stage, we're at roughly the halfway point of the trial, and we thought it would be a good idea to get a sense of where things are going, how the winds are blowing, talk to some experts to kind of shore up our understanding of what's happening right now. And speaking of experts, I've got Jennifer Rhee, a senior litigation analyst at Bloomberg Intelligence. Say hello.
Hi, everybody.
And we've also got Florian Ederer, an associate professor of economics at Yale School of Management. Say hello.
Hi, everybody.
And of course, we've got Shannon Lau on the line, a reporter at the Washington Post. Say hello.
Hey,
And Shannon, I'm going to throw right to you. Tell us about the very basic facts of the case. Where are we today, and what precipitated this whole trial?
right. Yeah, so to go over the entire trial, we should start back last year, last August is when Epic Games, did a hot fix for the app Fortnite on iOS and Android, where the hotfix would allow players to buy an in-app purchase from Epic directly and not through Android or Apple's proprietary processing payment platform. And so, therefore, Apple or Google could not make the 30% revenue cut they typically make. So as soon as that hotfix was patched into the two apps, that's when Apple and Google removed Fortnite from the app stores. And after that, Epic sued Apple and sued Google, and Apple and Google countersued Epic. That's how we got here. Then we had a hearing in September where the judge called Epic potentially disingenuous, for kind of starting this whole plan to begin with. And then now in May, we've started this trial last week, and now we're halfway through, like you mentioned. We've heard from CEO Tim Sweeney last week, including some of Epic's executives as well. And this week, we're hearing from Epic and Apple's expert witnesses.
Yeah. So, Jen, I want to turn to you. I think we're going to get into the merits, the details of both cases in a second, but I think the burning question that a lot of observers have, no matter what side they're really interested in, is how is it looking for both Epic and Apple so far? We're halfway in, and it appears so far that a lot of the skepticism from the judge has been directed toward Epic's witnesses. I'm curious what your read of the situation is.
Well, I would agree that so far we've seen skepticism from this judge, and it would go all the way back to September to the hearing that Shannon mentioned, where I think we heard skepticism then, and it's carried through to what's happening in trial. But that doesn't really mean very much. I mean, this judge has made it very clear that she sees this as not a slam dunk for either side, that she wants to hear out the economic experts from both. She knows the economic evidence is going to be very important, and she also knows that antitrust cases are fact-based. And what that really means is you've got to gather all the facts, everything, and understand the rationale for the business, the way consumers view the market dynamics. You have to understand all of that before really a decision can be made. So even though I think we've heard skepticism, I don't necessarily think that means that Epic can't ultimately win a favorable decision in this.
Yeah, that makes perfect sense to me. And I want to drill down now a tiny bit into what exactly the cases are, what exactly kind of the fact-based cases of both sides are. Can you tell us a bit more to start about what Epic's antitrust case against Apple is about, what it hinges
Sure.
on?
Sure. Well, it's a monopolization case. And in our antitrust world, that means it's under Section 2 of the Sherman Act. Now, that they brought some other claims that are under a different section of the Sherman Act, but really what they're saying is that Apple has engaged in conduct that is unlawfully maintaining a monopoly in a couple different markets. And they've defined the markets, one being the distribution of apps on iOS devices, and the second being the use of Apple's payment services in the App Store for buying the app or making in-app purchases. And what they're saying, because in the US, it's not illegal to have monopoly, and it's actually not even illegal to charge monopoly prices. So you really can't even just complain about the 30% that Apple charges to many app developers. What they're saying is that it's engaged in predatory conduct or exclusionary conduct. You have to allege that in order to make out a case under U.S. antitrust law that has had an anti-competitive or harmful effect in the market. And among that conduct, there's a list of conduct. They claim that Apple's rules that don't allow any other app distribution on the iOS device, and also that require Apple's payment processing services for app purchases and in-app purchases in the App Store. They call it tying, that distribution is tied to the use of Apple's payment services, that these two types of conduct are predatory or exclusionary conduct that are meant to unlawfully maintain its monopoly.
Got it. I want to get into Apple's counter case in a second, but you brought up the idea of markets and market power. And I imagine that the case kind of hinges on this, but in an antitrust case, how do you define a market? What goes into defining market power?
That is a really good question. And there are many different tests that have been used by courts or by the Federal Trade Commission and Department of Justice to try to define a relevant market. But to make it simple, it basically comes down to what products or services are substitutable in the eyes of consumers. So really, if I am using a product or a service and I don't like the way it's changed, or I don't like the way the price has increased, where can I turn to? And whatever I might as a consumer turn to, this is called demand side substitutability, that becomes part of the market. If I don't turn to any product at all, then whatever that product I have, that is the market. So the economists this week are testifying to different kinds of analysis that they've done to determine what the relevant market is here, because there are very big disagreements, obviously, between Apple and Epic. Apple claiming that Epics are both too small and too big, kind of at the same time. And that question is going to be probably the most important question answered in this trial, because if the judge sides with Apple on its market, which it says is digital game transactions, so I could do that through the App Store on my phone, I could do it on a PC, I could do that on a console, I could do it on an Android phone through an app I got from the Google Store, Play Store, which shows a lot of different competition. If the judge were to agree with that kind of a market, then Epic's claims that Apple has monopoly power, which it needs to show in order to win the case, probably will fail. So it's a really big question. And here, these experts this week are working to show how they've looked at customer conduct, customer desires, competitive dynamics to say how the market should be defined.
Got it. Florian, I saw you nodding along, even smiling at some of the parts of that answer. You're an economist. I want you to step in and tell us a bit about the different kinds of analyses. Take us into the weeds. What does it mean to kind of analyze? What does it hinge on when it comes to defining a market from an economist's perspective?
Yeah, so I teach an antitrust class at Yale School of Management, and one of the sessions is on market definition. And I often open this up and say, you know, economics it wants to be a social science, but one of the big questions in antitrust is market definition, and that often is more an art than a science, because there are many different ways of doing this. Some that are like particularly consumer focused, that literally go out and estimate if you have a price increase of a certain good, how much substitution away is there then from that particular good. Sometimes it just asks people, you know, if the price were to go up, how much would you, how strong would your intent be to go somewhere else? Often even these data aren't available, and it needs to be just sort of defined on what do people usually do, or what are the different technologies that exist and that allow us to switch. And you can already see in terms of the disagreement between the different expert witnesses that we've seen on both Epic's side as well as Apple's side, is they take very, very different views on this. And as Jennifer hinted at, how you define that market is going to be really crucial of how the judge eventually probably is going to rule on this case here. If you make it nice and broad and just say it's all about games distribution, okay, then of course the consumer has many, many different ways of substituting away. Suddenly, you know, the 30% charge that Apple charges, yes, that raises prices for consumers. Yes, it raises also the cost essentially for developers. Are these developers now not going to develop for the platform? Okay, well, we don't know. The analysis of this is it's a counterfactual, is what we call it in antitrust economics, but we don't have quite that information. Both sides are sort of trying to say, look, in one situation you can make it very, very broad and there are many, many, many options. The other side, that's Epic side, is saying, look, once you are on the iPhone platform, once you are on iOS, you are not really going to switch. The switching costs are very, very high. And Susan Athey, I think, gave a the expert witness more on the Epic side. She gave a very, very compelling case that said the switching costs are very high. People aren't going to switch. And so even if the prices go up, maybe there isn't all that much substitution. And maybe we're defining the market far too broadly. Maybe the market should just be defined distribution just on the iOS platform. Okay? And if it's only about distribution on the iOS platform, then immediately becomes very clear that this is a monopolization case where Apple has what is called in antitrust speak a little bit like an essential facility. And now it's raising prices on that essential facility, and the consumers have nowhere else to go. The developers have nowhere else to go. Too broadly, maybe that sounds a bit like abuse of market power to me. But of course, that's just one side of the argument.
And yeah, I want to leave this next question kind of open to the floor, but when I hear that there are multiple theories, multiple possible interpretations, I have to ask, how does a judge decide which of these interpretations is valid? Is there a reigning theory? Does it change over time? Do we have any guidance whatsoever on, you know, which direction the judge might lean, which of these interpretations is more legally valid? Is there anything like that to help guide our thinking?
Well, I guess from a lawyer's perspective, I can start on that. I think the first thing is it depends on the credibility of the experts. So as Florian already mentioned, which happens in every antitrust case that goes to trial, by the way, there are experts that have completely conflicting opinions after doing their analyses, and that always happens. And sadly, what tends to happen often is that they cancel each other out because of that. And a judge will basically throw up their hands as a generalist and say, well, I didn't understand anything the economists were talking about anyway, so I'm just going to go with the documents and I'm going to go with the testimony. I don't think this judge is going to do that. I think this judge is really paying attention to the economists and wants to know what they think. And so I think in this case, I don't think there's a prevailing legal theory per se as to how it should be looked at. But I think in this case, this judge is going to make a determination as to which of the economists she felt did the more valid analysis and was able to explain that valid analysis and withstand the cross on the stand. But our economists might have a different view.
Often economists and lawyers disagree, but I think here I agree pretty much with Jennifer. The whole point of these antitrust trials is, of course, to evaluate what the truth is, find out what the right definition is. But once the trial ends, I don't think either side really says, "Oh, we found the truth." Rather, we've established that one side has made a more compelling argument than the other side. I think it's particularly difficult here because it's very difficult to evaluate what exactly the right market definition is. It's the first. This is, in some sense, the first of these trials that deal with these tech platforms. There is, of course, precedent, a very famous precedent on platform cases, which is the Amex trial, which I guess Jennifer can also speak to some extent. And in fact, many of the expert witnesses, the economists that you've seen, in fact, on both sides, have also testified in that trial. And many of the same questions they arise is like, what exactly is the market definition? Is the market definition in the Amex case just American Express? Is the market definition all credit cards, and I'm not allowed to now steer consumers in one way or the other? Or in the App Store case, am I allowed to specifically rule out that the consumers can only pay through my App Store? Or would it be allowed maybe for the developers to suggest a link and say, here's how you pay a slightly lower rate if you buy it this way?
Yeah, I want to ask about precedent right now. A lot of the experts I've spoken to about this trial have brought up Qualcomm in kind of a worrying context. They're concerned that the Qualcomm decision from last year, is bad news for Epic. You brought up Amex just now. I'm curious if there are particular cases, particular recent decisions that factor into your perspective on how this trial is going to go.
You're asking me.
Yeah, go ahead, Jen.
Okay. Well, I will say at the outset, not just Qualcomm as well as Amex, but I think at least generally the law in the U.S. at the outset across the board favors Apple. We have over the years made it increasingly difficult for plaintiffs in monopolization cases to actually win, and the judges have been cautious and they have been business friendly, and we have developed a precedent that has made it very difficult, particularly where a defendant has valid pro-competitive justifications for its predatory conduct, even where that conduct might be by a monopolist or actually harms rivals. The defendant tends to win if they have some reason for the conduct that is related to their business and not just to hurt their rivals. And so I think the Qualcomm case is one of many, actually, that put Epic having an uphill climb here to win. And part of that is because Apple is arguing where Qualcomm won, that it's simply, this is its IP, and it has the right to license its IP on the terms that it chooses. And licensing its IP, it has to license its IP to app developers for their app to work on an iOS device, and that this 30% essentially is a licensing fee. And it has the right to charge what it wants to for its licenses, and that essentially what the court said was appropriate in the Qualcomm case. Likewise, the court said that Qualcomm didn't have a duty to license its rivals if it chose not to license its rivals. And that's another issue that Apple's raised here, that under the law, it doesn't have a duty to deal with Epic, let's say, as a rival game distributor, that it's simply our law and where the precedent sits right now says that even a monopolist can choose who it deals with and how it deals with the company. So it's Qualcomm Plus that and Amex and other decisions as well that I think favor Apple in this particular case.
Yeah. Shannon, I want to pull you in for a second. We've been talking about very high level legal questions around precedent, around the overarching arguments, around the spirit and word of antitrust law. Shannon, you've been following the trial, and the stuff that's been coming out has been questions about Peely, the Fortnite mascot. There have been conversations about itch.io. There have been all sorts of questions about defining what a game is. And I'm curious if you can kind of bring us up to speed on some of the recent conversations on the floor in the trial, and give us a sense of kind of what I don't want to say ambiance in the court is around those conversations, but bring us up to speed there.
Yeah, I'm glad you transitioned into that because I thought like there are some really fun highlights in this trial, and it's not all like very just news fest. I think it's become like entertainment for everyone tuning in, even if it's not available to watch. People are tweeting about it, and things are going viral. So I want to start off with Peely. It's a banana man in Fortnite, and Apple's counsel brought up Peely just to kind of allude to, oh, this is a photo of a banana man with a suit because when he's not wearing a suit, it might be inappropriate. And after Apple presented that in a redirect, Epic kind of responded and asked an Epic executive, do you think that Peely is inappropriate clothes on? And Epic was like, it's just a banana man. So that's something that I've actually interviewed both Jennifer and Florian about just yesterday, and that story is coming out soon. But I'm kind of curious for both of your thoughts. I mean, that's one situation. I guess I can quickly also mention itch.io, which is just a store within a store on Epic Game Store. And so how Apple brought that up was, this is an example of a store within a store, and there are sexualized apps in itch.io which you wouldn't allow on Epic, according to Epic Game Store's guidelines. However, because itch.io is inside Epic Game Store, therefore there are the apps. And Epic executive kind of responded, I don't agree with that assessment. Just because it's apps within an app, so it doesn't mean that we are distributing those sexualized apps. But then itch.io responded on Twitter saying, Apple's lawyers have called us, they've said that all gaming is illegal. Sorry, no more gaming. So that's also had some kind of viral blowback. So I'm kind of curious to hear from Florian and Jen, your kind of takeaways, and maybe Jen, you can start off.
Okay. I mean, first of all, lawyers and trials tend to get into minutia, and I would say some of what we're talking about here is definitely that isn't really going to move the needle one way or the other, depending on whether the banana man's wearing clothes or not. It's just not going to move the needle on anything. But I think it sort of just is the little bits and pieces to paint a bigger picture. And one of the things that Apple are very strenuously is that it has these legitimate pro-competitive justifications for its restrictions and policies. And part of that is to screen out the apps that are accessed through the App Store, and that it has certain standards it wants to uphold, and that there's a cost to that. And so part of what they're charging to all of these developers is the cost to do that, and that iOS consumers trust Apple and trust the apps that they download to not have, let's say, pornographic content. And so these are sort of like color. It's just giving color to that concept. And Epic Games has asserted, well, we also screen and we're also careful. And the itch.io example may be Apple showing that, well, that may be true, Epic, but we don't really trust you because here you have itch.io and that has content that people are accessing through your game store. And you want to put your game store on our iOS, and we wouldn't approve of the itch.io content, or at least some of the content, not all of the content. So it's just like little drops to paint the bigger picture, but it's definitely minutia.
So,
Yeah.
Florian, oh, go ahead, Florian.
Yeah, so I mean, I agree again with Jen here. The minutia are fun. The minutia are also interesting for an audience that isn't just into antitrust law, that isn't just
Right.
into antitrust economics. And let me just say, I work on antitrust. Usually when I start talking about my work, people start looking at me and their eyes just kind of glaze over and say it's kind of uninteresting what this is all about. But this trial here feels very much like the Super Bowl of antitrust economics, with all the superstar expert witnesses, with all the superstar antitrust lawyers engaged in it, Twitter talking about it, us here talking about it. And that means that this isn't just being fought in a sense in the antitrust court, but the whole case is somewhat fought also in the court of public opinion. So I think that might be somewhat intentional also by Epic and somewhat intentional by Apple, because they will know that no matter how this trial ends, a lot of information about the profit margins, the large revenue streams have come to light. A lot of maybe also about the restrictions and maybe some of the abuse of market power have come to light. And those aren't going to play particularly well next time that company has to negotiate a deal, or next time Apple, for example, has to show up in court or has to show up in a Senate committee hearing on antitrust. So I think that is these types of details, I think, somewhat also used to drum up not just interest in the case itself, or maybe sway the judge in one way or the other. Or as I said before, I think the judge is very, very good. I don't think she's going to be swayed by those minutiae, but certainly other people outside of the courtroom might be swayed by this or might be interested in this and see now where this is going to go.
So, Jen, I have a quick question for you about court of public opinion, and then I have a great question from chat from our tech columnist Jeffrey Fowler. So, court of public opinion. In the court of public opinion, Apple's saying, "Oh my God, itch.io is distributing these unmentionable, salacious apps." That, of course, reads pretty badly for Epic. Oh, Epic is distributing this app store that has all kinds of unmentionable, bizarre apps on. Um, but I'm wondering how much that actually factors into the antitrust case. Does the fact that, Apple wants to enforce its own rules matter on the merits in an antitrust case? Does the fact that you have these salacious details, do those details matter at all in the context of an antitrust fact-based case?
Well, it does matter in this case because what's called a rule of reason case. In monopolization cases in the U.S., the standard is called the rule of reason. It means it's actually just asking, is the conduct reasonable? And to determine if it's reasonable, you look at its anti-competitive effect, but then you ask, what are the pro-competitive reasons for the conduct? And if those pro-competitive reasons are deemed to sort of outweigh that anti-competitive or harmful effect, then the conduct is legitimate. So Apple here is going to argue, they are arguing and they have argued that their pro-competitive reason is for safety, security, reliability, the ability to keep malware and spyware and malicious apps off the iOS and to protect against fraudulent transactions and many other reasons for their restrictions. And so what Epic will do is try to prove that that is just a pretext. Hey, Apple's just saying that's not really true. They don't really need to keep other app distribution stores off their iOS in order to do that. There are other ways to do that, and it can be just as safe as a Mac OS. It lets you download software and apps from all over the place and not just through Apple. So there will be this battle of, is that true or is it pretextual? And so Apple bringing up things like itch.io on the Epic Games is just an example where Apple would say, no, it's not a pretext. We do need to screen each game by game, through our app store to keep certain content that we may not want accessible through Apple's app store and on an iOS device out of the device. So I think that there's legitimate justification for that discussion within the context of this case and the legal aspects of the case.
Yeah, that makes sense. And Jeffrey's question actually kind of follows along those lines to a certain extent, I think. He asks, how does consumer harm play into this case? If consumers are paying more for apps or don't have choice in the App Store, does that help tip the scales?
Absolutely, yeah. The guiding principle of antitrust law in the United States, although that's not everywhere the case, but certainly in the US, is the consumer welfare standard. So they're asking, is this hurting the consumer? The consumer here is people who play games, okay? But you could also say, well, maybe it's a two-sided platform. Maybe we also need to consider what are the effects on the developers, and the developers eventually, whether they do or do not develop games, does that feed then into the welfare that is created for the consumer? So absolutely, that plays a very, very, very big role. Proving that there is consumer harm is exactly the issue that's at stake here. How much harm are these restrictions causing? How much harm is the fact that you essentially every single developer has to pay a 30% tax on this stuff? How much harm is that causing in terms of higher prices for consumers? And how much of that is balanced through all the quality restrictions that Apple has put in place, that you do not see these pornographic apps, or that you do not see any of those low quality apps, or that you do not see any of these deceitful apps? How much of that balances up? And are these beneficial effects, these techs that help the consumer, that do not hurt the consumers, are they sufficiently warranted, or is there no other way of maintaining this type of quality? Is it really necessary to have these extremely strict restrictions? Is it really necessary to have a 30% tax on this? That is now then becomes basically the issue at heart in this case.
And I'll add that I think the judge is very focused on this consumer welfare question. I think it's a really good question here because she has raised repeatedly the concept that consumers can go and make app purchases outside the App Store, and Apple's getting nothing for it. That they can buy the V-Bucks, which are the digital currency used in Epic's game Fortnite, that they can do that on Epic's website, that they don't have to do it through the App Store. And I think she's quite focused on that. And that, to me, goes toward this question of consumer harm.
Got it. Jennifer, I know you have a hard out at 4:50. Shannon, before we let Jennifer go, do you have any big questions that haven't been asked so far?
Yeah, I'm kind of curious from a legal standpoint, what kinds of remedies do you think the judge could be considering?
I have a distinct opinion on what I think she's considering based on a few things she said. Now, I know at the beginning of this I said, oh, you can't go with what the judge says, and you can't. But I really think that this judge, based on what she's done in the past, is going to be very wary about forcing a big change in Apple's market structure and the way they do things. It's like forcing them to add other game distributors onto the iOS or allowing other payment systems. But I think she's thinking a lot about what Apple's anti-steering restrictions. And this is that for an app within the App Store, the app developer cannot advertise to its consumer that it can go someplace else to buy the product, buy the app, get the in-app purchases cheaper. And this is something she's raised a few times. And it may be that it's the only conduct in this case that she actually views as predatory as contemplated by the antitrust laws. And if that's the case, then what her remedy could be is just abolishing or prohibiting Apple from these anti-steering restrictions and making Apple allow the developers to be able to advertise in their app, in the App Store, that consumers can go somewhere else to make the purchases.
Got it. Thank you so much.
Thank you.
Yeah, thank you so much, Shen, for joining us. It's a shame you have to hop off now, but really appreciate you making the time.
Thanks so much for having me. I really appreciate it.
No problem at all. We hope to have you back sometime. If the
I hope
trial,
so.
there are any big other developments, we'll be sure to invite you back on. Florian, I want to talk to you about the economics of this case. And I guess first things first, before I start talking too much, tell me about how economics intersect with the facts of this trial so far.
Yeah, I think there's, as I said, this is a big time trial. Lots and lots of interest from economics, but also the general public in this. The way it intersects is pretty much the way we've outlined it here. So it's a monopolization case. It's a question of like, is there abuse of market power? Is there abuse of a monopoly position by Apple here? And how big are these welfare losses now, this harm imposed by Apple on Epic, on other developers, and on the consumers? So that's really the main economics of all of this. Since Jen here at the very end mentioned this stuff about the remedies, let me go back to that because I think it speaks to some extent to one of the most closely related precedent cases. Okay, and so here's, we stay a little bit with the legal stuff, but that was essentially the heart of the trial on Amex, okay, where Amex said, am I going to allow these stores to advertise that if the consumer wants to pay with a different credit card, they're going to get a lower rate? It's literally the same thing. Okay? It's sort of like telling the consumer here, hey, in the app, now you want to make the purchase, you can go on our website. And by the way, on the website, we give you a special discount. It costs us less. That's essentially, what this might come down to. And of course, Epic wants to have more even than that. They may want to have even lower rates on the direct purchases within Apple. But the sort of existing set of cases that we have on this is this Amex case that I'd say within the antitrust economics community is regarded as a terrible decision. Now, of course, there are some people that will disagree with me, but I'd say the consensus was that Amex decision was a terrible decision, and it basically kept these anti-steering provisions, these anti-steering restrictions alive.
Got it.
Is
So
that
actually,
is there enough of a consensus on this that maybe the judge has even recognized this? Maybe this is going to be different here. We'll see.
so
So for our viewers, can you explain what was the Amex case ruling, and is that good or bad for Apple or Epic?
So the Amex case ruling is great news for Apple, okay, which is also why one of their main expert witnesses is Dick Schmalzl, who was the expert witness for Amex there. Okay, and essentially there the question in that case is Amex allowed to really prohibit and kick off these merchants, or have really these exclusionary restrictions that basically prohibit the merchants from advertising lower rates of other cards. Sort of like if you come into a store and you don't see exactly what the merchant pays in terms of transaction fees when you pay with a MasterCard or with a Visa or with an American Express, they can't steal you because it's prohibited under their contract with American Express to go to tell you, look, it's cheaper if you pay with Visa and we'll charge you a lower rate for this. It's sort of similar here where the app developers, they're not allowed to say within their app, look, go to our website. There you'll pay a lower price because there we don't have to pay the 30%. That's essentially the same thing that's at play here. But in the Amex case, that was Amex won that case. Okay, they essentially were allowed to still do these types of anti-steering restrictions. And if a judge might say, well, there's precedent here, this is a similar two-sided platform that brings together developers and consumers. In the other case, it brought together merchants and consumers. This is the same thing. I'll just go with whatever the precedent is.
yeah. Shannon, you've been following the case really closely on a granular level. What has the conversation around steering been like over the course of the trial so far? What have the witnesses been saying? What questions has the judge raised? Bring us up to speed on that conversation.
Right. So anti-steering rules, as Jennifer kind of already mentioned, just means that a developer cannot, point uh, its customers to other ways to pay it that are not through Apple and Apple's ecosystem. And that was something that was really emphasized by the CEO of the yoga app last week. In his testimony, he said that his app would be rejected if he, include a link to another way to pay for in-app purchases for his yoga app, Down Dog, and even if it's like discounted and cheaper there through the website. So he was continuously rejected for that. That was his reasoning. That was his kind of argument there. And I think anti-steering also comes up like with David Evans's testimony this past week. Is also brought up, but I honestly actually have to admit that I did not listen to every moment this week, like play by play. But I wonder if Florian has thoughts about anti-steering and how it came up this week. If you can share.
Yeah, I mean, it's pretty much what I already said, which is that the developers would like to have this. If you can get 100% of the payment from the consumer rather than just get 70% of the payment from the consumer, then of course you would like to do that. But of course, Apple is arguing, well, as soon as we allow this, then all the consumers are going to go and they're going to go away. And then suddenly we will no longer be compensated for the services that we bring to the consumer here of running this app store, okay, which is we maintain the quality, we have these high quality apps, we make sure that you're not getting deceived in any particular way, okay? And so now maybe if you have now this new ruling that says it's no longer allowed for them to steer, Apple will have to do other things and they will be more distortionary. It will be worse for consumers. Okay? So the argument will have to be also like, are there ways of Apple still getting all the incentives of running a well-organized app store, allowing for the distribution of these wonderful apps and games, okay, while at the same time maybe having a more efficient arrangement? That's going to be what this is going to be about. I'd say it's, as Jennifer said earlier, this is a small part of the case. And it's sort of like almost an easy fix. So if the judge wants to do something that looks somewhat good, okay, that seems to be the right thing to do. But of course, it still leaves the whole other questions, like why shouldn't we allow completely that Epic just can have an app that installs itself on your phone, and then you just essentially have an Epic game store directly on your iOS phone. So that's essentially, the play they did when they went head-to-head on the PC platform against Steam. Ideally, they'd like to do that again, but Apple is arguing, well, it's a totally different system. It's a totally different business model. Therefore, you cannot just do that, and that's why we're kicking you off the platform.
Also from this week, I'm kind of curious your thoughts about, David Evans and Richard Schmalzi worked together, they collaborated together in the past, but now in this case, they are, basically on opposing sides, and Schmalzi is actually on trial today earlier today, kind of retorting against everything that David Evans brought to the case yesterday and the day before. So what do you make of both sides? Do you think that they were very effective, and what's your kind of take on everything so far?
Yeah, so first of all, let's say, both Richard Schmalzi and David Evans, they're excellent economists. They're very, very experienced expert witnesses in these antitrust trials, much, much better than I could ever do. So I admire what they've done. It's very entertaining to some extent that usually they are co-author team, they work together, they've collaborated on many, and suddenly they find themselves on the opposite side. It's not that they are mercenaries in any way. I think they truly believe that their understanding of this is correct. I'm not sure whether I can easily say one was more effective than the other. So maybe they're literally canceling each other out. I do think that what we heard from Susan Athey on the stand also was pretty compelling. But whether one was better or the other, I honestly cannot say. Some of the audio quality also was very, very bad. So it's pretty tricky to listen to some of the case at times. But yeah, I think Twitter did a good job sort of summarizing the arguments on either side.
Yeah, definitely. I think every single reporter who is not at the court themselves is struggling with audio, and we've made like various analogies of what it sounds like washing machine, someone's dropped their phone through it, or whatever it is, or like marbles in their mouth is what Jennifer called it yesterday. But I feel like I was listening to the beginning of today, and when the Amex case was brought up, the judge mentioned, Amex wasn't a duopoly. And I don't know what she means by that. I don't know if she's talking about Apple and Google or a duopoly or something. But it seemed interesting to me that she kind of interrupted Shimalisi to say that. I don't know if you have any thoughts on that, but also he seemed to make a lot of analogies to kind of bring us back into this analog world of like cows, like an iPhone is a cow, or
Yes.
the credit card terminal is like the in-app payment processing system. So the credit card terminal is part of the the payment process, so it's not its own separate market. Anyway, yeah, just any thoughts on today's?
I think it's very much, in the interest of Apple of making this seem very similar to the MX case, because there, essentially the court found that nothing's wrong with what Amex is doing, and ideally that should then mean, oh, there's nothing wrong with what Apple is doing. It's, yeah, they are charging these very, very high prices. Yes, they are having these very restrictive rules, but that's okay because they created this entire ecosystem, or similarly, Amex created all of this. Why? Often these analogies are brought out so as to really make it clear to the judge. And we're talking here, of course, we're on a video gaming podcast, on a video gaming show here, okay? And all of us are super familiar what in-app purchases are, and all of us are super familiar what game stores are. But for the average antitrust judge, that's not the case. So I think it's very important often to bring in these analogies of saying, like, look, this is similar to this case here, or abstract away from all the jargon and the stuff that all these experts are throwing around. I'll boil it down to you, make it easily understandable in simple terms. Okay, and here's what this is. And so I think that's why all of these analogies, cows or credit cards are being brought up, because it makes it somewhat more accessible for a non-video gaming audience to understand.
Yeah, speaking of like, strange analogies, I think the judge also asked, Tinder, is that like Fortnite where you need to have an account? And various kinds of questions like that to give a sense of, I don't know. I don't actually know how familiar she is with video games, but it doesn't seem that familiar from those kinds of questions. But I know that you yourself are a gamer. Do you want to talk about how your familiarity with gaming?
Yeah, actually, let me go back to the last point you raised. So there is one part where the judge needs to be impartial. So it is not really the judge's responsibility to be informed about all the ins and outs of the case before we come to court. Okay, it's sort of it's incumbent on the parties themselves that they come here. They need to make a clear case, which was sort of like what is more important. So it is important to them to explain it to the judge. So to some extent, the judges almost want to signal like, I do not understand this at all. I'm coming to this with a completely open, impartial mind. And now you, just on the merits of this case, are going to explain to me what is actually happening. So I'm not sure whether she's truly like didn't understand Tinder versus Fortnite, or whether one needed an account or not, or whether it was just a way of her to probe basically the defendant or the plaintiff in this. I think she's very, very sophisticated. And so, I made fun of this a little bit myself on Twitter, but I think she's actually right in sort of coming in and being impartial and being unbiased, just looking at this with fresh, open eyes. If, you wouldn't necessarily want to have a judge in here that is an ardent gamer, because that ardent gamer is going to say, what? 30% on being charged in commissions to buy Apple? That's crazy. How can they charge so much? And all my games are so much more expensive. And in fact, let me go back again to the Amex case. Like, one of the things where one of the judges misspoke on those cases was that they said, like, we as the consumers of Amex cards, sort of like saying like, oh, I use these Amex cards, I love all these benefits that they're giving me. And that was heavily criticized, and rightfully so, as saying, oh, you're being not being impartial here. You're taking sort of the side here as like, you want to have all these great benefits of Amex, and that's why maybe you are not quite as unbiased as you should be as a judge. So it's better that the judge is maybe not a gamer or doesn't know anything about Apple and so on, because that allows them to be somewhat unbiased. Now, for me, yes, I do like gaming. As you can see, I'm wearing a Zergras t-shirt. I'm back in the day, I used to play a lot more StarCraft, but we do talk a lot about video games nowadays, actually, in many of our competitive strategy and antitrust classes, because it is an increasingly larger part of the economy. And as you can see with this trial here, it's also increasingly part of like big time lawsuits. And there's going to be more of that if you look at all the big tech lawsuits that are coming up against Apple, Google, Facebook, and so on.
Yeah, that's super interesting. I don't know if Mikhail has any questions, but if I can just jump in with another one. Like going back to the court of public opinion that you mentioned, I find that very, very interesting. Do you find, okay, so let's see. So who do you think is trying to play this in the court of opinion? Is it more Apple or Epic, or do you think both of them are trying to like treat this also as a PR campaign?
I would say it's mostly Epic, because you saw that they were ready as soon as that lawsuit really took, as soon as they were kicked off the iOS platform, but they came out with an app. They came out with a commercial, and the commercial was exactly as a take on the famous 1984 commercial that Apple ran. So I think they were very, very prepared to say, okay, we're going to go to court on this. We are going to make sure that everybody, and not just the antitrust community, is going to know about this. And we're going to try and mobilize forces. It is somewhat similar because they did something similar to when they did this, when they competed against Steam. Okay, where also they really relied on many of these gamers saying, oh, we want to have access to this, we want to have lower prices, we want to have access to all of these games. Maybe they thought, okay, we can do something similar here. But of course, it's not just games on iOS, on the App Store there. It's lots and lots and lots of other apps. Like, is anybody who's not a gamer paying all that much attention to this? I'm not sure. Has Apple realized that they're also being judged here in a court of public opinion? Absolutely. I think they're very, very aware of this. And you know, the Peely stuff and the itch.io stuff, all of that is evidence that they're not just trying to influence the judge, but they're also trying to somewhat shape public opinion, and potentially not just public opinion, but also politicians' opinions on this. Because with the antitrust investigations underway, and some of which are also focused on Apple, okay, they might not want to have situations where like all of that stuff comes up and shows that says, look, you are making gigantic profits here off the backs of these consumers that somehow do not see this hidden tax of 30% that they're paying through paying the higher fees on these games because the developers are paying the tax.
Yeah. That brings me back to something from CEO Tim Sweeney's testimony from last week. I think he was talking about how, you know, so he was actually cross-examined by Apple Counsel, and they asked him, you know, what has changed since you signed your contract with Apple like 10 years ago? Have any terms changed? And he said no. And it felt like Apple is building this case that Tim Sweeney is in this for personal profit, to try to make more money over time. And obviously Fortnite was really successful in the interim between the 10 years, and now 30% is too much. Do you think that's an effective argument, or, you know, what is your kind of perspective on that argument from like the economics of it? Like, does it look bad to say, oh, this guy just wants to make money, so therefore we throw out his argument?
Yeah, usually no. I mean, making money is not, or being big or making money, being profitable is not an antitrust offense. That's not illegal, and you know, and we want our businesses to operate profitably. The issue in antitrust is like, are you abusing your market power? Are you abusing your market position in a particular way? The argument is saying, oh, well, we've always done this. Now suddenly somebody takes offense with it. Now somebody is really saying like 30% is too much. They're saying like, look, that's nothing has changed. We've just always done all of this. And the only reason why suddenly somebody takes offense is because they themselves, with their content, they have sufficient amount of market power. So it's Epic coming in and saying like, yes, everybody wants to play Fortnite. Everybody wants to play Fortnite also on mobile platforms. We are sufficiently powerful to maybe challenge Apple. And previously, yes, everybody hated it. Maybe that they paid 30%, but just nobody was in a position to challenge it. I actually thought that, you know, Spotify, which has a similarly strong bargaining position, okay, I would have thought maybe they would have taken Apple to court early on this. But essentially, any content type provider that wants to pay lower fees on the App Store, they would want to make this argument that 30% is too much. But yeah, it's very much in line of saying like, it's just two sides here. If you're a very small developer, you need to develop for Apple, and if it means paying 30%, that's just what it is. You just have to take it. But suddenly, if you're Epic with Fortnite, it's a totally different question.
Yeah, I'm kind of curious about the antitrust landscape right now. One of the things you mentioned was that, you know, the prevailing attitude is that we want companies to be successful, but that has kind of meant different things over the years. And I know that right now, a year ago, the Trump Department of Justice intervened in the kind of Qualcomm decision and said, actually, we don't actually agree with this. The Biden administration, on the other hand, Tim Wu has become a part of the administration. Lena Khan is joining the FTC, or has been nominated to join the FTC.
Yeah, that's happening today. Yeah.
Yeah, I'm wondering if administrative changes, if different kind of legal perspectives, whether timing plays a role in how this decision might come down.
I don't think that there's going to be too much pressure from the outside on this decision, because I think the judge is probably not influenced by this at all. But of course, the antitrust landscape has changed massively over the last decade. You wouldn't have me on this show a couple of years ago because, as I said, talking about antitrust is super boring and nobody cared about it. But suddenly, and I see it with my own MBA students or PhD students, suddenly everybody's interested in antitrust. Suddenly there are all these questions about, is there too much market power? Is the profit share for corporations too large in the United States? Is there too much abuse of market power? These are, I think, interesting questions, and I think they're going to be important going forward. And there certainly has been a tremendous amount of change on this over the last decade. I don't think it's going to influence this trial. It will, however, potentially influence what will happen after the trial ends. I could imagine, other than just these anti-steering restrictions being eliminated, that there might be some legislative change that says, look, you're not allowed to charge more than 20% on this stuff. We're going to cap the types of fees that you're going to require, or there might be just direct regulation. Rather than antitrust lawsuits, we're going to have regulation of these types of platforms.
Yeah,
What do you oh, sorry, are you still?
I was just going to say that was a good answer. So go ahead.
Thank
Shannon.
you.
Yeah. So what do you kind of envision if there were to be more restrictions on Apple's App Store, or if they had to open up the App Store? What do you kind of envision would happen to the economy then, and what would things kind of look like in your imagination?
That's extremely hard because the prediction about the future, prediction about the counterfactual. First of all, as I said before, I don't think they're gonna open up the App Store in this way. It's just the only thing that I can really envisage is they're gonna allow maybe some of the developers to point consumers directly to their website and tell them, look, here's how you pay, that is cheaper for you, or doesn't require us to pay these things. What would happen if you didn't have all of these restrictions? Maybe we'd go back to something like the earlier days of Google and Android, where there was a lot more site loading. There were a lot of apps that were stores by themselves. I mean, I vaguely remember myself installing the Amazon App Store on my Android phone. That no longer really exists. That was essentially what Epic is envisioning. If that were to happen, it would be, maybe it would be a kind of a free fall and would be interesting and exciting. Certainly some people would then have concerns about like, are these now going to be more deceitful or low quality apps? And we've seen some of that, much of that before. There's all of this evidence back for video game consoles. Like, they also wanted to control everything about their ecosystem. Nintendo was extremely stringent about what types of games were being allowed to be developed for their platform. Was that better or worse for the consumer? Very hard to say unless we unless we let it happen. So I'm going to have to probably pass just on my prediction of what this is going to look like.
No, that's perfectly fair. It's very difficult to forecast, especially given, Tim Sweeney's total ambition is to essentially make the phone look a lot more like a computer, and what happens at that point is anyone's guess. Yeah. Shannon, do you have any more questions?
No, I mean, unless we wanted to do like a historical view of the 1900s versus now, but I think we can skip that this time.
We'll
I think
save
that would
that.
be it.
We'll
Go
save
ahead.
that for some other time. But yeah, if people are interested in this type of stuff, it's antitrust is suddenly hip again, and the big debate is whether we should go back to how we used to do antitrust before people like me, like the economists, arrived. And so maybe we'll do that in some other episode.
Yeah, we'd be happy to. Thank you so much for coming on. Again, our guest was Florian Eder, Associate Professor of Economics at Yale School of Management, and before that, Jennifer Rhee, a litigation analyst at Bloomberg Intelligence. I usually